टेंशन आहे का तुम्हाला आमच्या सकाळी चलते झालं ना मग
Pavan, it's 8-1. We start.
Okay, sir. Just 1 minute.
Amrit,
Sir.
should I start?
Sir, we'll start.
Yes, sir.
8-1.
I'll mute
Hello.
everybody, and those who are host and co-host can unmute themselves.
Good evening, everyone. Welcome all of you to this 18th edition of Thursday Musings. Today is a bit a change in format, specially requested by the speaker. We won't have any PowerPoint. We will just talk and talk on the legal issues, mental aspects, how to do practice and all those things. So next slide, Pawan. So I'd like to welcome Professor Dr. Tufan Pati sir. He is our leader. He is guiding us in this program. He is National Advisory Board member, IAPP, Chairman of Membership Subcommittee, IPS, Life Fellow of many organizations. He has great organizational skills, organized many conferences, seminars. He has given lectures, multifaceted personality, and received Madhu Swabhiman and 4 Avenues of Service Award. So, Tufan Pati sir, over to you. Please take over the session.
Thank you, Alim, and good evening, everybody. I have the pleasure to welcome everybody to this webinar, Thursday Musings. And first of all, I would like to introduce our moderators, vibrant moderators, both EC members in the future of IPS. Dr. Amrit Patjoshi is a neuropsychiatrist, psychotherapist, and wellness consultant in Bhubaneswar. He is the professor and chief consultant of neuropsychiatry in High Tech Medical College, Amri. Direct Council member of IPS, editor of Odisha Journal of Psychiatry, which is indexed, and he is the chief coordinator of UNICEF, WHO, and IPS initiative on telemedicine on psychosocial management during COVID-19. And we have with us also Dr. Aleem Siddiqui of Lucknow, is the director of Healthy Minds Neuropsychiatry and Behavioral Sciences Center in Lucknow, is the visiting professor of psychiatry in ERAS Lucknow Medical College Hospital in Lucknow and GSB Medical College Kanpur. He is a direct council member of IPS. He is a guest faculty in Amity University. He is the finance secretary of IMA Lucknow and finance secretary of IAPP of UP and Uttarakhand chapter. Welcome, Aleem and Amrit. And I have the pleasure to introduce Dr. Sanjay Kumawat from Mumbai, our esteemed chairperson, is the director of Inside Mind Care Center in Thane. He is a consultant psychiatrist in Fortis Hospital, Jupiter Hospital, and Hiranandani Hospital. He had been a member secretary of State Mental Health Authority of Maharashtra and deputy director of Mental Health Government of Maharashtra and medical superintendent of Regional Mental Hospital in Thane. Welcome, Dr. Kumawat, and thanks for agreeing to chair this session. And we have with us Dr. Naveen Kumar. Dr. Naveen Kumar is a professor of psychiatry and head of the community psychiatry unit of NIMHANS. He is consultant in forensic psychiatry, legal aid clinic and services, telemedicine center. He is adjunct professor of Center of Psychological Support in Disaster Management of NIMHANS. He has 220 publications in national and international journals and more than 20 awards. Welcome, Naveen. Thanks for accepting our invitation. And above everything, welcome Suresh to our midst. We'll have a nice seminar. Now on the meeting, this webinar, I am handing over to the chairpersons for further proceedings. It is your stage now.
Thank you, sir. Can I speak, sir? Dr. Kumawat, sir? Sir, please unmute yourself, sir. Dr. Kumawat?
Dr. Sanjay, sir.
Sir.
Okay, sir.
I will start now. Hello.
Yes, sir. Please, sir.
Now it is up
audible?
to chairperson.
Am I audible?
Yes, you are audible.
Yes, sir. Yes, sir.
Hello.
Yes, you are audible, sir.
Yes, sir.
Yeah. Go ahead. So I will start now with the Thursday musings. At the outset, let me thank the IPS Odisha branch and my senior Dr. Tufan Pati, my colleague Dr. Amrit Pattadoshi, and of course Dr. Alim Siddiqui for giving me the honor to chair this particular session. It's my privilege, in fact, to honor the session where my dear friend Dr. Suresh Badamat is going to speak on managing the legal issues in practice. Friends, with rising awareness among the caregivers and the patients, the legal issues are getting further complicated. People are becoming more litigious, and thus it has been almost a situation where at the end of the day, we need to think that whether I did the things legally right or whether I was clinically right. And we need to now onwards find a balance between legal things going rightly and the clinical things also going rightly. As Samuel Abraham from CMC Vellore rightly said, that the doctors and the judiciary speaks different languages. And this particular difference creates a friction between the both. The situation is further complicated by the Delhi High Court decision of 1995, wherein the medical profession was brought under the ambit of Consumer Protection Act of 1985. And thus, the relationship has further gone from a very close relationship of trusted family doctor, and it has become a challenging relationship, and little mistake here and there on the part of the caregivers or the medical service fraternity, problems arise, doubt arises in the mind of caregiver, the patients, etc. Thus, with the law taking an upper hand, and it is becoming such a problematic that the relationship has become between doctor, patient, and hospital into an unholy mess. And this always sword is on our head, hanging all the time when we are in practice. How to balance this, then the law and the medical practice within the realms of our clinical guidelines and the ethics and values and the prevailing laws of the land. We would like to hear it from Dr. Suresh Badamat. To introduce him, I invite Professor Dr. Naveen Kumar.
Thank you very much, sir. I'd now like to formally introduce Professor Suresh Badamat. I think he needs no introduction, but just for the sake of it, he's a professor of psychiatry at NIMHANS, and also he heads the forensic psychiatry services as well as telemedicine services, and is a consultant in the community psychiatry unit. He's also the visiting faculty at the prestigious National Law School, Bangalore, of India University. He has more than 270 publications in national as well as international journals, has been recipient of prestigious awards, including the C.V. Raman Award and Distinguished Young Teacher Award of the IPS Karnataka, and the C.V. Raman Young Scientist Award is from the government of Karnataka. He's also a member of various committees at for the central government health ministry, and has been the member of the Central Rules Drafting Committee of the Mental Health Care Act 2017, and he's in the task force of the mental health care in primary healthcare centers. So it's pleasure inviting Professor Suresh to this program. And now I'd like to hand over the program to the two moderators to take forward this, moderators and speakers to take forward this program. Yes, Aleem and Amrit, please, the stage is yours.
Thank you, Dr. Naveen. Thank you, Dr. Suresh, you are all ready?
Yeah, ready, go ahead.
So like we have a different format where we actually have a PowerPoint presentation by the speaker, followed by a lot of question and answers from the, by the moderators, which are stimulated by whatever discussion goes out in the chat box. But here we have, pinpointed certain areas, and then we'll be asking you questions on that. So, Aleem, you want to start?
As always, I can, and you can wait.
Start.
So there are a few important things that we need to discuss. So Mental Health Care Act is there. और उसके आने के बाद से बहुत सारा confusions है, बहुत सारा complications है. Now, Suresh boss, can you tell us how to register under MHCA? Suppose I am running a single, I have just OPD service. So उसको कैसे register करना है? IPD को कैसे register करना है? And if state authority is not formed, so how to go about it? So boss, kindly cover this spectrum. As you are, we are also inviting the questions from the audience. We'll put up with the speaker live.
Okay, thank you. At the outset, I would like to thank the Odisha IPS and also the most respected person, Dr. Tufan Patti sir, and also the moderators. Before I start, I would like to have a disclaimer. Whatever we are discussing today is more of academic in nature. It's not a legal opinion. It cannot be alternative for a legal opinion. If you want to have a legal opinion, please do contact an advocate. So that's first. The second important point I would like to put across is during the discussion, I may take certain names of case laws. So they are all reportable because of Supreme Court, which has said that. So there will be no breaking of confidentiality. So no need to become emotional. With this outset, the first question was regarding Mental Health Care Act registration. Of course, the Mental Health Care Act has come into force from, I think, 29th May 2018. For today, it is almost 30 months. That means it is already on. So that means we have to register. So who has to register? All IP inpatient has to register. Register because OPD doesn't require registration. But inpatient, we have to register. Where to register? The CEO. CEO means usually either the commissioner or the health secretary becomes the head of the state mental health authority. If the state mental authority is formed, well and good, send the application in the format which is there in the central rules. You can send it. Or else, if the state mental authority is not formed, send it directly to the state health secretary, a copy to the commissioner, a copy to the NHM. So either of the three people will be the CEO. Once you send it to them, and if they have not formed anything, state mental authority is not formed or state rules are not formed, already state rules have been, a model rules has been given by the center. If they have not formed the state rules, that model rules of the center will be applicable. So now if they don't respond in 45 days, you are deemed to be registered. Already many of my friends who had called me and asked me, what should I do? There is no SMHA has been formed. I don't want to name those states. They have sent the letter and they did not respond after 45 days as per the legislation, section 66(19). They are deemed to be registered. If they don't respond in 45 days, it is a permanent registration. So go ahead and you will be registered. So that is the registration part, Dr. Aleem. Any other questions regarding registration, please do send it. At this point of time, there is no minimum norms have been formed. So need not worry, since neither the central government or neither any of the state government has formed the minimum norms for registration. So you go ahead, send them. If they don't respond, it is permanent registration. Go ahead, Aleem.
Yeah. What do we write in the application that I have such and such center with so many beds and I want to register? What is the format for sending the application?
Yes, as per if you look at the central mental health rules, they are clearly mentioned that what is the format you have to send it. And there is a simple application is there. You have to fill the application and send it. So that apply. Over to you, Alim and Amrut.
Okay. Amrit.
Sir, in continuation with the registration process, sir, what are the minimum requirement for establishing any mental health establishment? And what
Yeah.
is provisional registration and permanent registration under the MHCA, sir?
Okay. Amrut, see, it's like this. If the registration has to occur, there is two types. One is provisional and permanent. The provisional registration comes into picture when there is no minimum norms are set. So minimum norms has to be formed. But we already have submitted the central mental health regulation, meaning it has not been notified. If they are not notified, they will be only provisional registration. Once the minimum norms are gazetted, then it becomes the permanent registration. So till the minimum norms are there, the permanent registration. If it is not there, then it will be provisional registration. So it is depending upon when they are notifying the minimum norms. So minimum norms already been submitted to the government. The government has to notify under the CMHA, that is Central Mental Health Regulation. Similarly, State Mental Health Regulation will come in. So if they don't notify at all, please send your applications. And if they don't respond in 45 days, as per the legislation, you are deemed to be registered for more than 5 years. Permanent registration. That's the wordings have been used in the Act. So it is a blessing in disguise.
Okay.
Over to you,
How will
Amrit.
we know? How will we know whether my state has a mental health authority in place? A question in the chat box.
Okay, but basically you have to check with the whoever was the previous state mental health authority member secretary, talk to them, or else you invariably state mental authority websites will be there. Contact the NHM or the commissioner, health commissioner. You can even ask for a RTI whether state mental authority is formed or not. On that basis, you will get it. It's a information which should be available as per the law. And if it is there, fine. If it is not there, send the application directly to the state health secretary, or a copy to the commissioner, copy to the NHM. And if they don't respond within 45 days, you have a permanent registration as per section 66(19) subsection. You will be registered, permanent registration will be given, which will last for 5 years.
So there's a question in continuation is what we have been discussing. Somebody has written that, good evening, sir, I'm a child psychiatrist. What is the procedure to follow if I want to start an autism training center? Not clinic, more like a therapy center for early intervention in a metropolitan city. Can I start it in a residential area? Under which authority will this come?
Okay, if it is a OPD basis, no need for any registration. If it is, imagine if it's just a morning to evening, the children come and go, no need for registration. It's a OPD basis. If the patients are going to stay overnight, yes, it has to be registered. And if it is a training center, it has to be registered under RPWD Act. RPWD Act doesn't say that it has to be overnight, but it says if you are not going to register under Mental Health Care Act of 2017 and you are running a training center for rehabilitation, invariably you have to register under RPWD Act. So there you have to register.
So if it's a standalone clinic, you don't need to register.
No.
OPD clinic.
Since it is autism and he is trying to run a rehabilitation or a training center, that means it is a rehabilitation. So RPWD Act will come in. Mental Health Care Act will not come in because it is OPD basis.
Sir, what is the definition of this training center? How कैसे पता चलेगा कि training center है कि OPD है?
No. So that's what, see, State Mental Health Authority has to come up with or CMHA, Central Mental Authority will come up with the minimum norms. And also in the minimum norms, when they are making, they will categorize different types of inpatient mental health establishment. It may be acute care, long-term care, de-addiction center. It may be a de-addiction center, acute care, long-term care. So they will, or else it may be a halfway home, long stay home, sheltered accommodation, or even supported accommodation. These are the various categories which are there for inpatient care. So I don't think they will make it for OPD. And what we have submitted for Central Mental Authority is only inpatient. So the training center OPD basis, invariably it will come under RPWD Act, not under Mental Health Care Act. Over to you, Amrit. Amrit or
for therapists working in non-rehab population.
Okay.
Is there any declared process under Mental Health Act?
I could not understand the question, Dr. Alim.
So the question is, for therapists working with non-rehab population, is there any declaration process under Mental Health Act?
Non-rehab, see, OPD basis doesn't require any registration.
Okay.
OPD basis doesn't require. If they are going to be a inpatient, whether rehab or non-rehab, if it is a persons with mental illness, they are going to deal, they have to register, and it is inpatient, they have to register. If it is OPD basis, day boarder, non-rehab patients, the issue of registration comes under Mental Health Care Act is persons with mental illness, if you are going to keep them overnight, has to be registered, except home. Apart from their house, they have to be registered. And even if it is non-rehab cases, if it is a persons with mental illness, they are going to keep at home, keep in a center overnight, they have to be registered. In a simple term, simple words, I'm telling you.
Dr. Gautam Sir has raised his hands to ask a question. Dr. Gautam Sir? Sir?
Gautam da.
Hello, Dr. Suresh. One thing, why, if I want to do some outdoor basis only,
I think Gautam Da would have by mistake would have raised the hand.
No, sir.
Oh.
Hello. What I want
Yes, sir.
to know, can you hear me?
Yes, I
Yes, sir,
can hear you.
we are hearing you. Suresh?
If there is a child and adolescent clinic is there, fully outdoor basis, I mean special educator.
Amrut, I'm unable to get any question.
Hello.
Suresh?
I can't hear the question. I'm not able to get the question.
Okay,
from...
we'll repeat the question to you.
Okay.
Gautam da, please go ahead.
What I
Gautam?
want to say
Yeah.
that if there is totally outdoor basis child and adolescent clinic, like there is a special educator, occupational therapist, but it is not a daycare. There is no chance of getting admission over there. So is there any need for registration or like that? Hello.
Yes, boss. Suresh boss, are you getting my voice?
No, I can hear you, but I could not hear the Gautam Sir's.
Okay,
question.
Gautam sir is asking
Okay.
that suppose he is opening a child adolescent clinic. He has occupational therapist, clinical psychologist, and all the staff is there. So should he get it registered, or it is out of purview? Only OPD work he is doing.
OPD doesn't require registration.
Even if
Very
he is
clear.
handling child population.
Anything OPD basis doesn't require registration under Mental Health Care Act, but it requires registration under RPWD Act.
But it requires
Right to Persons with Disability Act of 2016, they have to register. Most probably Gautam Da has to register under RPWD Act. Unless if he is going to run an inpatient care overnight stay, then he has to register under Mental Health Care Act.
No, boss, if OPD is there, only OPD of child population is there, then we
Not
go
re-
under RPWD, you are saying.
Yeah, because it's like this. Mental Health Care Act only takes care of inpatient registration. Okay, now that doesn't come under Mental Health Care Act. RPWD Act is very clear. It says that if it is not registered anywhere else and it is a rehabilitation center, maybe inpatient, outpatient, anything, has to be registered under RPWD Act. By chance, if you are running an inpatient and you register under a Mental Health Care Act, you send the copy to the RPWD commissioner. That means it is deemed to be registered under RPWD Act also. That means either one of them you have to register, either Mental Health Care Act or RPWD Act. You have to register in one place. So RPWD Act will play here.
Occupational therapists are there, they're looking after the children, and that has to be under RPWD.
Yes, it will come under RPWD, OPD. Any rehabilitation centers has to come under RPWD Act.
Okay. Rao sir is wants to speak. Rao sir, please unmute yourself.
Yeah. One important question, Suresh. If
evening.
in a general hospital or a corporate hospital where there is a psychiatrist is practicing, and he might admit a case or he might see the cases which is, fit into the definition of the new Mental Health Care Act. According to the current new Mental Health Care Act, do that general hospital unit of psychiatry, or you can say general hospital, do they need to be registered? Especially think about delirium, think about other cases where psychiatrist is called, and some definitions of psychosis is fitting into the general hospital.
Okay, sir. Thank you for the question, sir. The question is very clear. If a person, psychiatrist working in a general hospital setting and is going to treat a patient who is admitted inpatient, definitely they have to register, sir. If they don't register, he may say that I'm treating only delirium or something. If the patient dies, the delirium is high chances the person may die. And Mental Health Care Act, state mental authority, they will come and definitely question, and it will be very difficult to defend the case. So any general hospital unit where the patient is going to be admitted, you may call it in various names, or it may be delirium, you may call it as dementia cases or other, it may be alcohol withdrawal, acute. I'm seeing on OPD basis, but the patient is admitted inside, they are referred to OPD. Invariably, the law says if the psychiatrist or the mental health professionals, not only psychiatrist, any mental health professionals knows that this institute is not registered and they are continuing to work there, first punishment will be 25,000 rupees penalty. I think section 107 or 108 of Mental Health Care Act talks about this. So invariably, all GHPUs, wherever the patient is going to be admitted, especially persons with mental illness, that needs to be registered, sir.
So that in itself is stigmatizing, then you can say, wherever psychiatrist goes, special law is there. So the law is stigmatizing in itself.
Alim, that's a good opinion, but unfortunately, on the other hand, one is stigma, another one is the persons with mental illness are kept in a various rehabilitation center, like a sheep or goat or maybe like an animals, they have been kept without getting registered. And if you want to know why it is to be registered, why this has been come is because of the Constitution of India. Constitution of India, Article 21 clearly says right to life and liberty. And if you are going to curtail somebody's liberty, it has to be by a law. That law is Mental Health Care Act. Without that Mental Health Care Act, you cannot curtail a liberty. You can curtail a liberty either through Indian Penal Code, otherwise no. So that means you need a law to curtail liberty. That liberty is Mental Health Care Act. Where to curtail the liberty is registered places. So otherwise, no. So it's basically this Mental Health Care Act gives power to the psychiatrist to detain a person. Imagine even a cancer patient cannot be detained against his wish and will. If he may die tomorrow, but he says, I don't want treatment, none of the doctor has any role to play. But with persons with mental illness, section 89, 90, and even 94 talks about treating him against his wish and will. That power given to the psychiatrist or the mental health professional under this legislation. You may call it a stigma, yes, but that is the law. It goes, and it is there in almost every country. Over to you, Alim and Amrit.
Yeah, one question, like if for inpatient treatment registration is compulsory, somebody has put, is it compulsory in private medical colleges also? Because we see a lot of private medical colleges where admissions occur and there's no, nothing called registration involved in that.
Okay, it's not only private medical college, government medical college also has to get registered if they are going to admit. Even private nursing home has to get registered. Wherever the patient is going to be admitted, please register. And one of the things which I have seen recently is our psychiatrist or the mental health professionals, maybe even clinical psychologist or a psychiatric social worker or nurses, they give their name to a nursing home. They don't know, they have given the name. Whenever the patient comes, they are going to see them. But unfortunately, many a time they do not register. They think that we are going on OPD basis. And many a time it happens is they admit in your name. And something goes wrong and your name is there in the hospital. Whatever you say, they say that you knew this hospital is not registered, and the first penalty will be given to the mental health professional. So better to work in those institutions where it is registered and insist those institutions for registration. Because on one hand, as a mental health professional, we talk about various institutions, they are not registered and they are treating like animals, maybe in temples, maybe church, maybe masjid, they are tied up and beaten up, or even some rehabilitation. There we talk about human rights. But when it comes to us for registration, you have a double standard. Why should I register? The law is same for everyone. So you also have to register. Even the temple, masjids, church, where they are going to detain a person with mental illness, they also have to register. The law is very clear. Wherever a person with mental illness liberty is curtailed, they have to register.
So what
Are
about
there any charges for registration?
Charges for registration for Central Mental Authority, IP Care, it's basically clearly 20,000 rupees. But however, Chhattisgarh state rules have come out. They are very clear. They have made some slabs. Karnataka state mental health rules have been yet to be gazetted, but the approval has been come from the central government. They have made a slab. I think 50 beds, it is 5,000, and 100 bed 10,000, and then above 100 beds, it is 20,000. So, but however, the central rules talks about is 20,000, whatever the number of beds. But it is left to the state to make changes. Some states have made changes, some states have not made changes. By the central rules, it is 20,000 rupees.
So this will be clarified by the state authority.
A state authority, if they make any changes, they will clarify. If they don't make any changes, you have to send a 20,000 rupees DD or a check.
Yeah, one corollary to the question. So a lot of people go to private rehab centers where patients are admitted. People go and see patients on a daycare. They see once a month or maybe once in 15 days and come back. So do we now, whenever we need to go to a rehab center, should we check for their registration if they are not
I will
registered?
definitely, because the wording of the Mental Health Care Act is very clear, Dr. Amrut. It says that if you know that institution is not registered and you are still working, it is an offense under the legislation. So
And if
insist for those rehab where it is registered, for the registration. If they don't register, don't go and work. Even don't provide telemedicine services, because the wording is very clear. If you are working for an institution which is not registered, that means you are party for the crime, party for the offense under the Mental Health Care Act.
So even if there is an emergency and if somebody calls up and tells that this is somebody is having a withdrawal fit and he's having like this, we'll tell we will not attend your call.
Amrut, it's a very interesting question. Excellent. Section 94 talks about no registration. You can treat anywhere, any place, any situation for 72 hours if it is an emergency. What is an emergency? The emergency should be such a scenario where person is so severely ill or he is going to kill himself or kill others. It's a life and death situation. That is the situation. Section 94 emergency treatment can be given for 72 hours. Within 72 hours, you have to shift the patient. You can provide care. Hope I answered your question, Amrut.
Yeah. And another corollary to that, suppose I get a call from a hospital which I know there is no registration for mental health under the SMHA or something. So, and if I really need to admit somebody, should I admit him under a neurologist, under a medicine specialist, and then treat?
Okay. Actually, I think that is going on. That is actually going on, Amrut.
Amrut, it is like this. Amrut and Alim, see, there is a traffic signal. Many people are breaking the rules. Okay. Excellent. The day one person is caught, he has to pay the fine. So you can go ahead and do it, but unfortunately, if you get caught, you have to pay the fine. That's the way it is. And by chance, if there is some death and something happens, you'll pay a very heavy fine, because the chances of losing the practicing license may go ahead because you are deliberately violating the law. That may be a big issue. So let's be very cautious and let's insist for registration. See, that's the biggest paradigm or a dilemma which I've seen in psychiatrists. Okay. If I ask Amrut, Dekhbhai, there is a rehab in your place near Cuttack, which is not registered. They are admitting like animals. You become angry and say, oh, they are not registered. But when it comes for you to register, you do not register. Why this is double blind? Why I would like to ask question both the moderators, Alim and Amrut. Why this is two different opinion? Why?
Alim.
We want others to register, but we don't want others to register. Why? Why is this?
Yeah, because my friend neurologist or cardiologist who is seeing the patient, who is seeing my psychiatry patient, is not registering. I was going to add on this question. Boss, suppose you said that कि traffic signal पे पकड़े जाएंगे, so उनका क्या करें जो neurologist, cardiologist and gastro physicians who are seeing the psychiatry patients. So what to do? Because now we are seeing that they are seeing schizophrenia, bipolar, और उसमें whatever they want, they know they write. So are they culpable under these laws?
Okay, let's see, the law is same for everyone. So even whether it is a cardiologist or neurologist, anybody, they also have to register if they are treating a person with mental illness. The question comes is, because I had discussed with one of the Justice of High Court who is retired, I think next month we are going to interview a High Court Justice, Justice Pranindra sir, who is agreed to come online. He is answering this question and I have spoken to him. Before he answers, I am answering it. He said, if you are admitting for the person for neurological issue, so the question of mental illness doesn't come. If you are admitting a mentally ill patient for the treatment of mental illness in a neurology ward, then the neurologist and the psychiatrist who is going to treat will be taken into task. Imagine if a person is admitted for MI, cardiac ward, and he is also coincidentally a person with mental illness, the admission is primary for cardiology, then the issue doesn't arise of registration. But in the name of treating mental illness, you're admitting in a cardiology ward. If that is there, it will be a severe issue. That's how the judiciary looks at it. That's the way the judge is going to discuss. And we have one more program which is called as HELP. We are interviewing the judges on the interpretation of Mental Health Care Act. The next, I think next Wednesday, that is first week of Wednesday of the December, we are going to interview. So that's the answer, Dr. Aleem and Amrit.
Dr. Rajkumar has raised his hands. Dr. Rajkumar, sir?
Sir, please unmute yourself.
Good evening, Suresh. I have one question for you. You know, a physician's nursing home.
I think we have to unmute them because we are the host and we don't allow anybody to unmute. Most probably we may have to unmute Dr. Aleem.
Sir is
Sir,
unmuted.
he is unmuted and he is talking.
I have unmuted.
I am unable to hear them, man.
Dr. Suresh, are you able to hear?
Sir, I'll repeat the question. Amrit will repeat the question.
I
You go
wish
ahead.
Amrit.
that there is a patient admitted in a nursing home. I admit my patient in a
Amrit,
physician-
repeat the question. I am unable to.
I'll repeat after I hear it. Let it be complete. Sorry, just wait.
Can I register that hospital under my name, or has it to be registered under the name of the physician only? Can I register on his behalf?
Like sir goes to a nursing home where he treats psychiatric patients. So now for the registration, does the hospital need to be registered under the name of the proprietor or the owner, or sir can register under the SMHA under his name?
See, in the what I understood is with whom name the registration should occur. See, earlier what used to happen is it used to be registration under the name of the doctor, like it is under Dr. Amrit or Dr. Aleem. Now it is not with the doctor because later it was found under Mental Health Act of 1987. A single doctor can go to 10 places and he used to shift those licenses telling that I have taken license in this hospital, in that hospital. Now it is not the doctor, it is the establishment where the license is given. So even if the Amrit is going for 10 hospital, all 10 hospital has to be registered. It is not Dr. Amrit who is going to get the registration. So that is the way. And one more question which I saw in the chat, it says, anybody can open a mental health establishment? Yes, anybody, even an illiterate person who has money can open an establishment. It doesn't require to have a degree of either MD psychiatry or DPM psychiatry or MPhil. Any person can open a mental health establishment, but minimum requirements has to be fulfilled.
Dr. Suresh,
Yes, Amrit, over to you.
Amrit, a second question too. For example, I am going to a rehab center. The rehab center is registered under the RPD, isn't it?
Amrit.
I'll tell you.
Okay.
It does need a secondary mental health registration. It is already registered in the rehabilitation thing. One of the two registrations is suffice, isn't it?
So sir is telling if sir goes to a rehab center and either it is registered under RPD or under the State Mental Health Act, does it suffice for him to go and see the patients there?
Situation question I am unable to understand. If it is a persons with mental illness, it has to be registered under persons under Mental Health Care Act. If it is rehabilitation patients, but still, if there are persons with mental illness, you have to see. You have to register under Mental Health Care Act.
But
Hope I
there will be
answered the
due-
question, Amrit. It's like this: if a person is persons with mental illness, and they are admitted, whatever name they call it, it has to be registered under Mental Health Care Act. If it a OPD basis kind of thing or a rehab center, which there is no persons with mental illness is there, they come on OPD basis, it will come under Rehabilitation Act. Hope I answered your question.
Either of the two act would be.
No,
registering
neither of
authority.
them, no. If it is primarily a persons with mental illness, it comes under Mental Health Care Act.
But if there is a dual diagnosis,
You can't say that because RPWD Act, the RPWD Act requirement for a mental health establishment will be very minimum. You can't say that I will not register under Mental Health Care Act. Mental Health Care Act will be primarily for any persons with mental illness, either acute or chronic cases, if you are going to keep them overnight. Once you register under Mental Health Care Act, a copy to be sent to the RPWD Act. and there is no fee to be paid under RPWD Act. So invariably, once you register under Mental Health Care Act, RPWD Act says that you are registered. But if you register under RPWD Act and say that I am registered under RPWD Act, I am not going to register under Mental Health Care Act, it is not acceptable because the Mental Health Care Act doesn't give that kind of leeway.
Okay, fair enough.
Okay.
Salim?
Okay. I think Ruma wants to ask a question. She was raising a hand. Dr. Ruma, would you like to ask a question?
rubbing
You
her
have to unmute yourself.
Yeah, can you hear me?
Yeah, Ruma.
Yes, we can hear you.
Yeah, okay. So actually, Dr. Suresh, I think already answered, but still I would like to ask him that like if I admit a patient, my old patient again with acute psychotic episode or is severely suicidal, like he said, okay, if a person is suicidal or is would be killing others, that is an emergency and you can admit. But like an acute psychotic episode, a fresh case or an old case, relapse, can I admit for like 48 hours, 72 hours in a general nursing home? And does that general nursing home needs to be registered?
Okay, Ruma, this is a very interesting question. You can't admit, you can treat them. See, it's a very fine, thin difference. See, when you go to any corporate hospital in an emergency situation, they don't admit. They open an emergency ECR, emergency card or emergency receipt. You treat on that only. If you make an admission, it has to be under section 86 or 89, it is 90. So don't admit. It is a treatment. So even in emergency, they don't admit. They continue to treat for even MI. In emergency situation, the admission will occur into the ward, not in emergency. So that if there is a minor changes in your hospital, you have to change that. So in emergency, you are going to keep them. See, if you read the section 94 of Mental Health Care Act, it says emergency treatment. It doesn't say emergency admission. So emergency treatment. So you are going to treat him in emergency, whichever place, even in a community center, even at the home, even at the patient's place, you can treat him. But don't say it is an admission. You say, we have started the treatment in emergency situation or emergency scenario. ECR can be opened, that is emergency sleep, or you may call it as emergency card or something. Don't say it as an admission. Admission means it has to be as per the Mental Health Care Act 86, 87, 87 will be for minor, 90, 89, 90. That is the way, or 100, 101 as per the police or as per the magisterial order or under 102. Hope I answered your question.
Yes, thank you, sir. Dr. Nikhil Patel.
Yeah, good evening, everybody. Thank you for having me to raise a query. Dr. Suresh, this is a query for you. I practice in Rajasthan. I am located at hill station Mount Abu. And
shall we shift a little, Alim? Can we go to record keeping and all, or are we having more questions on admissions and all?
I think one or two questions. After that, we shift to the next phase. Let Dr. Nikhil finish here.
Can I go ahead? Can I go ahead?
Sir. Yes, sir.
Yes. You see, as far as my knowledge goes, the Rajasthan state hasn't yet notified the act. And we sent a letter. I practice in a charitable multi-specialty hospital run by Brahma Kumari's charitable institution. And I sent an application to the State Mental Health Authority, the Ministry of Health. And the letter was returned back, stating that I want to apply for the mental health, establishment under this act. The letter was not received. And how do
Guys,
I
I'm not
go
getting
ahead
the
about
question.
it? I mean, I just wonder. Yeah.
Okay.
Can
Dr. Nikhil sent a letter. It was not received. It was returned back. I think what Dr. Suresh has covered, that within 45 days, your center will be considered automatically registered. Is it, Dr. Suresh?
Yes.
If
I see
his
they
letter,
ask
Dr. Nikhil's letter is returned.
Yeah, Mental Health Care Act is very clear. Either they have to reject or they have to give the registration. If they don't reject or they don't register, after 45 days, you have to have a evidence telling that I have sent the letter or I have submitted the application. Full stop. It will be registered. That is the law. The law has been very clearly written, and the magistrate of whichever court is there or even the Mental Health Review Board, they will say it is considered as registered.
If it is returned or rejected, what are the grounds usually?
Reject means they have to give 6 months to rectify. What is if they are rejecting, suppose if they are going to reject an application, they have to give why they are rejecting, what is the basis for rejection, and they will give 6 months for rectification as per the Mental Health Care Act. If they don't just send the letter back, that means it is registered.
Even if the SMHA is not there, so now if our SMHA is not found, I need a permission and I don't have the requisite, I'll just send a letter, and then after 45 days, I'll think that yes, that's it.
Yes, because the wordings are very, very clear, Dr. Amrut. If they don't respond in 45 days once the application is been sent, best is either registered post, make a 3 copies, one to the, if they are not made SMHA, the SMHA CEOs in across the country, I was able to involve in at least some of the drafting of certain state. I have seen either the health secretary becomes the CEO, or else the health commissioner becomes, or the NHM, MD NHM becomes the health CEO. Send a copy to all 3 of them. So one of them has to reject. If they don't reject it in 45 days, that means you are registered. That is the way the law clearly says. I'm not saying that, because this kind of harassment to the doctors or the harassment to the mental health profession was seen earlier. Hence, the law has been written like this. If they don't respond, or they don't even bother to see it, it is deemed to be registered. But you should have evidence that you have submitted, full stop.
So we shift to record keeping now. Alim.
Just one question, role of police and magistrate. I think, so what is the role of police and magistrate in admitting a patient? Suppose a wandering patient is there, so usko utha ke hum le aayenge, kaise karenge? How do we?
Okay. See, under Section 100 of Mental Health Care Act, it is very clearly written, if a person with mental illness is roaming around or creating a nuisance, the jurisdiction police will pick up the patient and directly take him to the public mental health establishment, not to the private, public mental health establishment, and they will drop him into the establishment, whichever public mental health establishment. Now the doctor in charge of that hospital has to decide whether they will admit under 89, 90, they will assess him, they will assess the capacity. If the person has mental illness, they will admit him under 89 or 90. No, if he doesn't have mental illness, he will be allowed to walk away freely. The police may have to take him back and drop him wherever they have picked him up. That is under Section 100. Now moving to the Section 101. Under Section 101, if a person with mental illness have been ill-treated in their area of jurisdiction of the police station, the police will pick the patient, or else if somebody gives a complaint to the police telling that a person with mental illness has been ill-treated by some family or somebody, so the police has to register an FIR, pick the patient and take him and produce him in front of the magistrate. The magistrate under Section 102 will give an order for admission and assessment for not more than 10 days. That is the reception order, maximum 10 days. After 10 days, what to do? Within the 10 days, the psychiatrist or the doctor who is in charge of the establishment has to decide whether whether the patient has capacity, he doesn't need to be inside the hospital, he will discharge him, or else he will shift them into Section 89 or Section 89 basically. That is the role of a police and magistrate. And the role of magistrate has been curtailed very severely under this act. And the role and responsibility of the psychiatrist and the doctors and the mental health professional has been increased enormously, because the doctors will be held responsible. This is a very simple reason was it used to happen in Maharashtra. Now also it is happening. I had an opportunity to visit one of the mental hospital where they have done is they have admitted patients who are there for since 10 years, 20 years, 30 years. And when you ask the hospital administration, if you ask them, they will say, sir, we have admitted under the reception order. Where is the reception order? 10 years back, the court has given an order and the doctor did not bother to discharge because the doctor said that, sir, koi nahi aaya ghar se, so hum idhar hi rakhe hain. Where should we send it? Send them. That was the question. So that is the reason the Lord, whoever has drafted the law, thought that let's curtail the role of the magistrate. Let us put the responsibility on the mental health profession. So if it is a psychiatric social work is made in charge, or the psychologist or the doctor who is in charge should take the responsibility once the patient gets the what we call it as capacity and the request for discharge, you have to discharge, and set the liberty should be given. See, we are very, very emotional. Either Dr. Alim or Amrut or myself, we are very emotional about our patient. Yes, very good, we are emotional. Let's understand, when there was a lockdown, we were allowed to stay in our house for 30 days. How did we feel being at home for 30 days? Imagine a patient as kept in a mental hospital against his wish and will in an unknown circumstances environment. How will he feel? Being at home, you find it very difficult. Imagine for a person with mental illness, even one day he wants to go outside and feel that fresh air of freedom. That should be given freedom. That is where the Constitution of India comes in. Nobody will be arrested or detained in anywhere, any place, in any manner by anybody, unless it is as per the law. It should be under Indian Penal Code, or else any other law. It may be Mental Health Care Act, or else it may be some other act. Hope I made my point very clear why this is a very big issue, and liberty is very, very prime.
Very clear, very clear. Amrit, phase 2.
So there are certain questions like what medical records to be kept under MHCA 2017 for both inpatient as well as for online consultation. And Suresh, let me tell you, we have a lot of practicing clinical psychologists also. So
Okay.
they would also need some input about those things.
Okay, coming to excellent question, Dr. Amrut. The question is clearly what record should be kept. Let's first talk about the in-person, then we will move to online. So in person, we have psychiatrist and also psychologist. See, first and the foremost is, as per the section 25, clearly it says every person with mental illness has a right to basic medical record. That means the patient has a right to take that medical record. So you have to maintain that basic medical record. But unfortunately, when the rules were drafted, the lobby was very high. The OPD also has been mandated to keep certain minimum basic medical record. Even if you are seeing on OPD basis, either it is a psychiatrist, psychologist, or psychiatric social worker or nurses, they have to keep basic minimum records. If the patient is going to ask you about the basic minimum records, you have to give for OP patients. IP patient, along with the basic minimum records as OP, there are some extra things have been there.
But
So
Suresh,
that
yes. What is basic minimum record? ये क्या होता है? What do you mean by
basic
it?
minimum record is basically, if you look at the Form B of the central rules where it talks about patients' rights, their Form B is the one where there is basic minimum records का format दिया गया है. उसमें Form B में 1 में OPD के लिए minimum records है. It is demographic details, diagnosis, provisional diagnosis, and medicines what you write. That is basic minimum records. For IP patient, it is like a discharge summary. But however, for psychologist and psychiatric social work, there is Form B C. I think Form B3 talks about psychological assessment. You have to keep a record. One copy has to be there. If you are doing therapy, every therapy session has to be kept. That is Form B4. So all these has to be kept. Even for each individual session, patient may ask for the therapy notes. You have to provide. So at this point of time, you should know what to record, what not to record. And the patient has a right for his records. Nobody else. It is only the patient. Let's be very clear. Basic minimum records, the request is by the patient and you will give it to the patient only, not to anyone else. That's the wording in Section 25 of Mental Health Care Act. Form B is there. But how to give those records? Form A as an application has to be filed by the patient to the either the psychiatrist. If it is a psychologist, they have to give that application. Then you will give those basic minimum records as per the format which has been given under the Form B of the state central rules. That is about the in-person. Coming to online. Online, again, you have to comply with the Mental Health Care Act. It's just that I will go ahead with the telemedicine guidelines. Just a prescription is enough. Yes, prescription is enough because it's almost goes with the outpatient record of the basic minimum record. But however, even if you are providing care under telemedicine practice guideline for psychiatrist, you have to comply with Mental Health Care Act. You cannot say that, no, sorry, online de raha hu, I will focus only on telemedicine practice guideline. It is now under National Medical Commission. It is not applicable. It will not be listened. You have to follow Mental Health Care Act. For the same psychologist and psychiatric social worker, sir, I am doing therapy online. I am not going to keep the Form B 3 and 4. That is basically assessment and therapy copies. I'm not going to keep a copy. Again, it is a contravention of the law. Whatever format you are doing the providing services online or in person, you have to keep the records. So what format, whether it should be a digital or physical? In the rules, it has been written as physical. If you look at in bracket, it starts as a physical. So you may have to keep a printout. You can keep a digital copy that is basically in the format in the cloud or in the hard disk, but you have to take a printout whenever the patient asks. You have to give a physical printout. You are not going to give a digital printout, and that is the reason it is written as a physical form. Hope I answered question, Dr. Aleem and Dr. Amrit.
You've answered the
बस
question. but-
कितना पुराना रिकॉर्ड
जी?
रिकॉर्ड कितना 25 साल पुराना रिकॉर्ड 3 साल
Okay, how many
5
days
साल
you have to
पुराना?
keep the record? Okay, so
Yeah.
there are two different groups are there, psychiatrist and the psychologist and social worker. For psychiatrist, for inpatient, it is 3 years as per the medical council, currently NMC, as per the regulation 2002 ethics, you have to keep it for 3 years. That is the only. But however, in the regulation, we have specified the date for inpatient and outpatient. Once the Central Mental Health Authority regulation comes in, then there is, I think, 5 years, 10 years, something we have written. So that will be, if it is not changed, it will be there. For psychologist, as per the Central Mental Health, as per the regulation, they have to go. That has not been notified. Once it is notified, you have to keep for those many days because they don't come under MCI.
Yeah. So the OPD record to be kept for how many days? How many years?
OPD record as per, again, that we have specified under the regulation, Dr. Aleem. Once the regulation is notified, there it is mentioned. I remember OPD 5 years and inpatient 10 years. I remember we have specified it.
So you mean that there are a lot of practitioners who go to small clinics, 2 hours there, then somebody else comes and sits. So physical form, maintaining records in physical form, and psychiatry records are not very thin records. So what about this space? What there are a lot of logistic issues. There are a lot of, you shift, aaj aag lag gaya, kal barish aa gaya, the shop shuts down. So how so it is so cumbersome. So is there any method which we can, circumvent such things?
Okay, Dr. Amrut, it's like this. Whenever the law is implemented, law is same for everyone, for Amrut also, for me also. Whatever issues you said, aag lag gaya, or the thieves may come and take away the records, that also can happen in the NIMHANS also. It is the reasonable degree of care to maintain those records. You have to do that. And you have to prove it in the court of law that I have taken a reasonable degree of care. In spite of that, aag lag gayi. So it is beyond my, what we call it as, beyond my capability. So it happens. So it can happen with Dr. Aleem, it can happen with me, any other hospital, even it can happen in AIIMS. So that cannot be prevented. So there you have to prove that I have did a reasonable degree of care. If you look at the telemedicine practice guideline, there also it clearly says, if the doctor has shown that he has given a reasonable degree of maintaining the confidentiality of the data, and the data is hacked by somebody else, the doctor or the psychologist or the social work will not be held responsible, clearly written. So that reasonable degree is the one which is required. Whatever Dr. Amrut would do, I should do. I should not do something which is different, all other psychiatrists do not do. Imagine, if we are going to keep the medical record in a safe place, it may be kind of maybe a room or very clearly maintained. You are not going to keep it in a veranda or somewhere, which is completely a negligence. There it will be fine. No, sir, I have kept it in a MRD and it is under so-and-so person who is looking after it, or I am the one who is keeping it on that day, aisa ho gaya. Because of short circuit, nobody will hold you responsible.
But Suresh, it is so easy for you to tell because you are sitting in NIMHANS. It is just like this for you. But look at somebody who is doing it Sitamarhi, somebody who is doing in a remote, place or in a village. Where will he keep records? Like suppose somebody goes to a district place, he goes to a remote place. He sees patients there, maybe 100 patients. He goes once a month. He's doing a lot of service. He's earning a money. That's a different. So where will he keep the record? So each passing day, where is the space?
Okay, see, Amrut, there are two questions. There is a two parts to your question. One is legal answer. Another one is practical answer. So I will talk about legality. Practical answer, you have to find the answer. Legality is every doctor, whether he is in rural area, urban area, semi-urban area, he has to keep the whatever records. To keep that records, whatever format, wherever you want to keep, reasonable degree of care is required. You don't require to keep it in a safe lock like bank. Reasonable degree, jaise ki Aleem ne kiya, Dr. Aleem is going to do, or Dr. any other Mr. X is going to do, you have to do similar way. Or Dr. Naveen is going to do, you have to do it. Whoever is the private practice, whatever they are going to do, you have to follow that procedure. which is accepted by everyone. So if you do that, the court will not hold responsible. But if you are not kept the record, you are not even written the record, obviously it will be considered as a negligence. So practicality, I don't have the answer. I'm talking about the legal, what is the requirement?
So the people who are going to periphery and seeing 100 patients in a day, I think they are breaking the law.
If they don't see, they are not breaking the law unless they don't keep the records. They can see 1,000 patients. The law doesn't restrict. You keep the record. You can see 1 lakh patients. Keep the record. See, this is the words used by the then chairperson. They said, we definitely raised this issue that many hospitals, they run what they call it as camps. Forget about even private. Even the government hospitals run camps in the periphery. When they go to the camp, there will be maybe 150, 200, 300 patients. They would have just come for refilling the medicine. Should I keep the record? Yes, you have to keep the record. Let's be very clear. That was the words used by then chairperson. And also it was vetted by everyone. Nobody raised the issue. We said whether it is a camp, whether it is any format, you have to keep the record. OPD basis record has to be kept.
Sir, you are speaking about the form B and C. There are certain people who wanted the forms. If you can share it and with us, we will share it in our
Done.
Facebook page.
Central rules. I'll be sending it to Dr. Aleem and Dr. Amrut. They will be able to send you those forms. Basically, it is the central rules which talks about the rights of a persons with mental illness and the mental health rights of the mentally ill patients. That's the rule that has to be followed. There, Form A is for application, B is for the basic medical record, C for independent admission, D for something. So these various forms are there. Under that, I'll be able to send it to you.
So
some people are asking, yes, are we recording the session? We are recording the session. We'll place it on our Facebook page. And whatever material Dr. Suresh sent will also be at our Facebook page, Thursday Musings at 8. This is the page. On this page, we'll host the material. Amrit.
Suresh, about the record keeping, you talked about inpatient where you have to write the provisional diagnosis or the differential diagnosis and the treatment for the psychiatrist. In the OPD records, like we keep, do we need, like I see a lot of people only writing the medications. Do we need to write the diagnosis or the symptoms or the problem? What should be a standard record keeping or the basic things? Because today I make a diagnosis of panic disorder. After 2 months, it turns out to be schizophrenia. A lot of fluctuations in the diagnosis changes. There are a lot of schizophrenia comes to schizo-obsessive, obsessions comes into, So what should be the standard legal proper manner to do a OPD, keep a OPD record and an inpatient record? So these are the minimum that is required, sir.
Yeah, very good, Dr. Amrut. This is a valid question, which is very oftenly seen in legal documents, especially when I am admitting the patients in forensic psychiatry. I have faced this situation because what happens is JR will see and make a diagnosis, SR will see and make a diagnosis, another diagnosis, and then another one of our faculty will see make another diagnosis, and a grand rounds of forensic psychiatry occurs. It's a different diagnosis. When the whole file goes to the court will ask which diagnosis is correct, JR ka diagnosis, or else it is the psychologist diagnosis. So the best way is make a provisional diagnosis or a differential diagnosis. Today it is schizophrenia. Okay. Is there any rule? It is written in the book. It can't change. It can change. We have seen even in CIP Ranchi, even in Nimans or any mental hospital. Today they have a panic disorder. Over a period of time, they may develop schizophrenia. A patient who has schizophrenia may also have social phobia, or else a patient who has been diagnosed as mania, over a period of 2 months, the diagnosis may change as schizophrenia. Be ready to accept. Yes, this question was raised to me in the court of law. Sir, आपने लिखा है 1 साल पहले कि it is mania, bipolar affective disorder, mania first episode. After 1 year down the line, I have made a diagnosis of schizophrenia. Then I said, yes, both the diagnosis is correct, because when I saw 1 year back, it was mania. Now I am seeing it has turned it to be schizophrenia. ये कैसा हो सकता है? Then I said, yes, 1 year back, a patient can have typhoid. This time he has tuberculosis. Medical diagnosis can change. Similarly, here also it changes. So at that time it was mania, now it is schizophrenia. Nowhere in no book it is written a person with mania will never become schizophrenia, a patient with schizophrenia will never develop mania or schizoaffective disorder. So we have to be flexible, and if you have a doubt, make a provisional diagnosis. Still you have a doubt, have a differential diagnosis. Because if you are going to give a medicine, any medicine, on what basis you are given? You have a certain doubts, no, it may be a differential diagnosis ho sakta hai, provisional diagnosis ho sakta hai, or you are treating a symptom of mania. Mention that I have a doubt of provisional diagnosis of mania, I am treating mania symptoms, full stop. So then whoever is watching, whoever is reading those documents will have a clear idea what did Dr. Aleem or Amrut think about this case. They thought it may be a mania and they have given the medication. So that medication for mania is right. So in that way, you have to make a provisional diagnosis, differential diagnosis. Coming to this has been very well written in telemedicine practice guideline. Telemedicine practice guideline clearly says that don't issue medication without even making provisional diagnosis. You have to make a provisional or a differential diagnosis or a diagnosis. Without that, you are not issuing any medication. That's very clear. It will be considered as a it will be considered as a ethical violation. The doctor may lose the license. That is very written in telemedicine practice guideline. So if you have a doubt, have a provisional diagnosis, even in OPD basis.
Yes, thank you. Dr. Vatve is waiting. Aleem. Dr.
Sir.
Vatve sir has been.
Welcome.
Sir.
Hello. Am I audible?
Yes,
Yes.
sir.
Namaste,
Yes,
sir. Namaste, sir. Vatve, sir.
Sir, unmute, sir.
Vatve sir, please unmute yourself.
Yes, I think now I have.
Sir.
Now, am I audible now?
Sir.
Yes, sir.
No, very simple question. The hospital administration books say that the OPD record should be kept for 3 years, IPD record for 5 years, and medical legal cases for indefinite period. What exactly is the situation in mental health according to Mental Health Act? OPD record 3 years, IPD 5 years, medical legal indefinite period. Am I right if I say so?
Okay, sir. Thank you very much, sir. Namaste, sir. Vatve, sir. Let me tell you, Mental Health Care Act has not talked about the duration of records. This is by the rule of law, by the case citings, they have said anywhere when you come to know that there is a medical legal issue, you have to keep it for indefinitely. That is by various court interpretation they have said. But Mental Health Care Act is very silent about this. But however, under Mental Health Care Act regulations, we have brought the duration, how much that I have to go back and see what is the duration we have written. Once it is notified, we will be very clear for OPD and inpatient, how much it has to be written. But we have not differentiated between medical legal and legal there. It is any record OPD and inpatient for these many years. That is there, but it has to be notified, sir. Unless it is notified, it is currently not a law under Mental Health Care Act, sir.
Thank you.
Suresh, suppose a couple is there and we are seeing a couple. अब उसमें लड़ाई झगड़ा शुरू हो गया and maybe separation का बात हो रहा है. So और वो जो रिकॉर्ड हमारा है that becomes sort of evidence कि वो हम लेकर उसको करेंगे. So इस situation में what to do? कपल में किसको देंगे, किसको नहीं देंगे, कपल थेरेपी का दोनों को देंगे, कैसे करेंगे?
Okay.
Because they are already not in sync.
Okay, Aleem, it's a very interesting question. Either it may be applied to psychiatrist or psychologist or psychiatric social worker who is doing family therapy or couple therapy. See, when you start a couple therapy or family therapy, you will maintain only one file. Okay, so because we are working towards the integrating the couple or integrating the family. That is the reason usually we keep only one file, not many files. So when you are doing a single therapy, during the therapy only you have to tell that this file is accessible for both of them. And you will record whatever the husband says, whatever the patient says, if you want to record verbatim. If you don't want to record verbatim, you make what is required in the Mental Health Care Act, Form B, the therapy notes is there, which is very, very minimal. Name, age, what kind of therapy, what are the things assessed, what was the goals. That you have to write. It's minimum requirement. That you have to write. And both has access for the records. You can't say only it is patient or wife. That is A. B, during the couple therapy or family therapy, you find that one of the family member is severely depressed. He may require CBT. He or she may require a CBT. When you refer them for individual therapy, though you may be seeing, then you will open an individual file for that patient. That file will be accessible to that person only, not for the rest of the family or the couple. Or else imagine husband has anger management problem. So you'll say you have to undergo anger management. Then when you are referring them to individual therapy, then a separate file will be opened. That file will be accessed to be him. Another scenario, when you are doing a couple therapy, you come to know that husband has ADS and you want to start a treatment. Don't do it in the same file because you are treating him. So you are treating, it will be individual. Then you will open a file under his name. That file will be accessed by him only, because couple therapy and the treatment of de-addiction doesn't go hand in hand. So then you will open a separate file for him and it will be accessible to him and he will get this. But for only couple therapy, and you are not violated the therapy, basically you are not deviating into another therapy or different format therapy or individual therapy, you are not going, both will have access to that file, and you can take consent before in hand that this is a couple therapy, family therapy. Every person who is going to be part of this therapy will be able to get the access of this therapy. That is the easiest way to deal. And sir, I'm going to record unnecessary details. Don't do that. Best thing is Form B, the therapy notes, which is very minimal, 1-page notes, half of them is already printed. You have to just write yes or no, simple.
Yeah, Suresh.
But suppose, Amrit, just a minute. But in therapy, something comes up, the wife says that husband has beaten me. Husband says कि नहीं थोड़ा धक्का धक्की हुआ था, was being pushed. So how to note this, because it can become a pointer later on.
Okay, see, we are doing therapy. Should we record that the husband has beaten her? The husband says, I have not beaten. So one is, don't go into the nitty-gritty of the recording, if you ask me. But if there is a legal implication like domestic violence, then you can say that the wife alleges or the wife accuses that the husband has beaten it, but the husband defers it. But on physical examination, nothing is there, or if it is there, marks are there. Or if the patient is able to produce a medical record or a medical treatment, that has been attached to the file. That you can keep. That is the best way. But however, legally speaking, the requirement for therapy is Form B. And Form B mein jitna bhi hai, it is very minimal. And I think if I have, give me a minute, I'll be able to show those forms, because there are many questions which are coming with regard to this. Unfortunately, I don't have. Okay, I have it. Yes, I'll just share the screen. Is it okay if I share the screen, Amrit?
Yes, sir. Sure, boss.
I'm unable to go for share. I think share is disabled.
No, it is allowed, boss. Again,
नहीं हो रहा है sharing.
You are allowed to share.
Okay, आ गया sharing आ गया. Just a minute. Yes, if you can see, let me know. You are able to see this?
Yeah.
Yes, sir.
Okay, see, this is the basic medical record Form B. This is the Form B, basic medical record for OPD, this much, basic medical record for inpatient, idhar tak hai. So assessment ke liye you have to fill this and keep it with you. After the assessment, you give a copy to the patient, whichever format you are giving, but this should be retained with the psychologist or a psychiatric social worker, whoever is doing the assessment. And coming to the therapy notes, this is the therapy notes, basic medical minimum records for therapy, therapist session notes. This is for every session they have to do patient name, age, gender, psychiatric diagnosis or provisional diagnosis you can make, session, objective of the session, this much, and sign it, full stop. This is the requirement as per the law. So would you want to write all those things is left to the therapist professional judgment. I would rather leave it to them, whether they want to write in detail, whether they want to censor something, whether they don't want to write or they want to do audio recording, video recording, it is left to the patient and the therapist, individual, what we call it as consent. Hope this is fine, no? Would you like to run through this form?
Very
this
helpful.
form is
Very
as per the central rules ka hai. So
send it to us, we'll share it.
Done, boss, done. Yes, sure.
Yeah, Facebook group. CL Narayan sir is waiting to ask a question. Dr. Narayan sir, please unmute yourself, sir. He's another legal luminary.
Yeah, if his question comes, means he'll ask a tough question. Sir, yes, sir. Namaste.
Namaste, Dr. Suresh. I have just one question that you regarding things which you told already some time before. You told that any health facilities where patients are being admitted.
I'm not able to hear the question.
Sir, I'll repeat.
Okay, any health facility where patients are admitted and the psychiatrist visits there, that has to be registered. The psychiatrist has to ensure that the facility has to be registered under the Mental Health Act, Care Act, that is MHCA. Suppose if no psychiatrist is working there, and the hospital runs for different services like cardiac services or anything like that, and the psychiatric problems like delirium, dementia, etc., it may develop there also. So what about whether those facilities are required to be registered under MSCA? Because you told us that any hospital where psychiatrist is visiting, even only for the OPD, and the patients are admitted there, the psychiatrist has to ensure that that facility has to be registered under the MSCA.
Yeah, Suresh boss. Sir is asking. Suppose there is a nursing home where a psychiatrist visits. There are nursing home where a psychiatrist is not visiting, and there are patients who develop psychiatric symptoms which are being treated. So does this nursing home need to be registered?
Okay, Alim, I have. What will be your response, Alim?
Sir, I think if there is mental health, there has to be a registration.
Okay, that is the best way to answer. Another one is if the primary care for reason is different. If imagine the patient has been admitted for various other physical illness and coincidentally there is a mental illness, there is no issue. But primarily admitting a person with mental illness in disguise of physical illness in a ward, that will be taken very seriously.
No,
Hope I answered, Dr. Alim.
No, sir.
But if because this question I had, because even Dr. C.L. Narayan has asked this question in the CPG guidelines presentation, I had the opportunity to talk to one of the senior judge. He has clearly said that why we are admitting, if the primary care for reason is mental illness and you are admitting and treating, it has to register. If you are treating for some physical illness and coincidentally there is a medical illness, for example, there are many patients who have stroke, we have comorbid depression. If you are treating for depression, for stroke, no need for registration there because depression is coincidental and your primary reason for treatment is the stroke. So that time it doesn't require and nobody will bother. The judge will or the judiciary will take it as a coincidental finding, no need for that issue. But if the patient is stroke is very remote, but the main cause is depression and in the disguise of stroke, you are admitting a depressed patient into a neurology ward. And if something goes wrong and the court comes to know it, they will take it very seriously. That is how it is interpreted.
So that means the psychiatrists are at disadvantage because if
over to you, Alim.
If they visit, the facility has to be registered. If they do not work there, it has not to be registered.
Thank you, sir. Thank you, sir. So, Dr. Suresh, there's a question. If you're doing a family therapy, the registration has to have all the members of the family name. Like you told in couple therapy, we have one file. So also if you're doing a session of family therapy, should all the members of the family's name be included in the registration process?
I don't think so, but if you are able to mention.
Alim,
Yes.
We have two sets of, Suresh, continue.
Yeah, see, this is again, it's left to the hospital administration or the individual hospital rules. If you want to register everybody's name, it is well and good. If you want to have only one name, that is also fine. But as soon as the file is written, hello, can you hear me?
Yeah.
If once the file is open, then you can say these are the members. When you do a pedigree charting, you will be saying these are the people who are there, and then you will go ahead with the therapy.
We have two sets of problems that we need to discuss now. So we will be moving on to some questions on suicide and on child sexual abuse. I think Alim, there will be time for these two sets of questions.
Yeah.
There's a lot of questions on child sexual abuse and suicide. So Alim, you can start on the suicide part.
Yeah, Rucha has asked, at times during history taking or therapy, patient talks about a past incident of sexual abuse in a passing manner. So, which is not a reason for consultation. So how do we document it? Do we document it? If so, how?
Okay, so this is a very tricky question, but however, I will try my best to answer because there is no complete right answer or complete wrong answer here. But however, the POCSO Act section 19 is very clear that we have to inform all child sexual abuse. It is nothing to do with the doctor or psychiatrist, anybody who comes to know. It may be father, it may be a mother, or it may be even another child. Because if you look at the section 19 and 21, which clearly says, even if the child comes to know that another child is being abused or getting abused, or there is a possibility of getting abused, it has to be reported to the police or to the SGPU, that is Special Juvenile Police Unit, has to be reported. Even if the teacher comes to know, warden comes to know, a third person comes to know, they have to report. So it is nothing special about doctors. So let's be very clear, not be very touchy about this. A. B. Suppose if the patient is around 50 years old or maybe 40 years old and he says, 20 years back, I was sexually abused. Okay. So now today is 2020 and the incident occurred 20 years back. 20 years back, Child POCSO Act was not there. That during the commission of the crime, the POCSO Act came only in 2012-13. So invariably that will not be hold good. No, sir, the patient is around currently 20. It happened around 4 years back when the child was 16 years old. That means there was a POCSO Act at that time. Now the person is major. That person, whoever is reporting about, you have to tell them that you have a right to go and report that there is a child sexual abuse has occurred to you. So that is A. So you can document that, telling that the person mentioned about ABCD, and then I have told them and their family member to report as per the POCSO Act. So that means they also will become responsible, that they also have to report. No, sir, the person who has abused is in a very high position, maybe warden of a hostel, and he has access to many children. That time you may have to be, because of social responsibility, you may have to go one step ahead and say, either you report or else we will be reporting, because that person has access to many children and he may be abusing them. So invariably you have to take the family into confidence and then only we have to report. So the issue here is the section 19 or 21, what the POCSO Act is very clear. We have to report. It doesn't say when to report, because the issue here is, imagine, let's make it as a one simple task. If your child, okay, it should not happen. I'm apologizing before in hand. Imagine if your child is sexually abused by one of your family member or a neighbor. You have to give a police complaint, write a complaint telling that my child so-and-so was sexually abused. Can you write your child's name and tell that sexual abuse? You will find it very difficult to write the child's name and sexual abuse, because even for a hypothetical situation, you find it very difficult. Imagine if it has happened. If it happens, you will be emotionally torn into pieces at that time, either you or your family members. That means you are in emotional turmoil. So that time, as a health provider, mental health professional, we have to sit together, talk to them. We have to do the ventilation session, bring them together, prepare the family to give a complaint. Just jumping and giving a complaint doesn't work. If you do that also, you've legally done a very good job. But if we will lose the case, because the family will say nothing has happened, because they are not prepared to give a complaint. They are worried what will happen to the child, what will happen to the child's future. The abuser is very strong. He may do something, and who will take care of me? The case will run for 10 years, 15 years. So these kinds of apprehension has to be decreased. Talk to them, record it. Family is in emotional turmoil. Family is not ready, not in a position to give any evidence. Child is not in a position to give evidence. Take all the address, family member's address. If possible, admit the patient in your ward, start observing the child, prepare the family, have an individual session with the child, have a family therapy with the whole family, because it's a very, very, what we call it as a situation which no family should face. They are going through such a turmoil, because that abuse cannot be explained. So you have to prepare the family, then you give a complaint. That is the one answer. But imagine if the child is bleeding and the child has a severe medical, what we call it as consequences, immediately record it, report it, and then send the child immediately for the medical intervention or maybe surgical intervention. That is A. B, if the child is going to the same, imagine father is abusing and the father is abuser, you are sending the child to the father again. That means safety of the child is very essential. If the safety of the child, if you are able to ensure you are going to admit in the ward, you can take some time, prepare the family, talk to the police, and then bring the together and then collect the evidence, make the case very strong, because you, me, and everyone wants to punish the culprit or the perpetrator. So that is our aim. It is not just washing our hands by giving a complaint. Earlier, I used to think that, no, chalo, we will give the complaint, let's whatever happens. No, it's a very, very sensitive issue. We have to be very, very sensitive. And first and the foremost is safety of the child. Whether we are able to face the safety of the child, we are able to admit, you can delay the process, prepare the family, and then you go ahead and do. If there are evidences to be collected immediately, please record it and start examination and then report it. If the abuse has occurred around 1 month back or 15 days back or 1 week back, there is no evidence available at this point of time, you can delay the process, take the family consent, take the family together. That is very essential in the POCSO Act. Hope I answered.
An add-on question. Yeah, boss, an add-on question. Suppose you told we ask the family that they report. So if the family agrees to report, so our responsibility is finished, or family has to report, and I myself have to report also separately.
So see, this is again a very tricky situation. See, what is happening is, earlier, wherever the crime has occurred in that jurisdiction, the FIR has to be done. That was the earlier. But now you can do an FIR in any police station. That is one. If the family is doing well and good, if the family doesn't do, then we have to do it. That is the way it goes. But
no, suppose I ask the family, this has to be reported, and they agree.
Yes.
So my job is done.
Yeah, I think if they are able to report by themselves, that's fine. But you continue the care.
And they promise me, and then they do not report, and so the onus is on.
Then you may be considered why you did not report. Then you have to say that the parents have reported and I have documented and I have taken the signature. Then it's a very tricky situation how the law will look into it. Whether
I think this is the document is I think the key point here. Document document the exchange.
Yeah. See, there are two issues here, Dr. Alim. See, again, this issue has been again discussed with one of the National Law School. We debated about this Child Sexual Abuse POCSO Act. See, at the end of the day, the judge will say, why did not report? What was the reason you did not report? If it was to save the culprit, you are making attempts to goof up the case, or you are making an attempt to क्या बोलते हैं, to allow, मतलब वो जो दरिंदा है उसको सेव करने के लिए काम कर रहे हो, then you will be punished. No, you are doing a job in that process, and they said that yes, they will report, and they did not report, they will be held responsible. The leverage will be given to you, and they may warn you and send you. That's the usual way. But if you have been found trying to manipulate the whole case by not reporting, then even if you have taken a signature from the parents, that will not work. It's basically the motive for not reporting holds good here.
Amrit, can we bring in Dr. Sabina Rao?
Yeah.
Dr. Sabina, you have to unmute yourself to ask the question.
Hi, Dr. Suresh. Can you hear me?
Yeah, we can hear you. Go ahead.
So it's a combination of a suicide question and an admission question. If a patient is admitted, general hospital, develops say steroid-induced mania and becomes so agitated that runs out of the hospital or jumps out of the building and dies.
Okay.
Now, and it's not admitted under you, it's probably admitted under neurology, neurosurgery for some other unrelated issue, but developed clear symptoms of, patient is on steroids and developed clear manic symptoms and did something impulsive and unfortunately succumbed. What is the responsibility of the psychiatrist? Because this hospital will not be is not registered under any of the mental health requirements because it's a general hospital. The patient is not under the psychiatrist, it's under the neurologist.
Okay, invariably in such a scenario, Sabina Rao, usually the judiciary will look into it, why he was admitted. The admitted for a maybe attempted suicide for poisoning, maybe pesticide or insecticide poisoning. During the treatment process, either by giving steroid or giving by atropine, he becomes delirium, he jumps out. Invariably, the judiciary says that you are not trying to manipulate. What was the motive for not registering? So this was not manipulation. So there was nothing involved. So invariably the judiciary or the state mental authority will not take any, what we call it as a harsh. But however, many a time state mental authority or the mental health review board, our own psychiatrist will be sitting, they may create a trouble. It's invariably our own people will create trouble. And I have seen many of our Consumer Act cases or various medical negligence cases. It is our own doctors who would have instigated the patient. Similarly, in mental health review board, we have another psychiatrist who may instigate telling that, oh, they have not registered. Imagine Dr. Alim may say, hey, why you are not registered? Then you may have to defend, or else you may have to pay 25,000 fine is the first punishment they may do, the way they interpret. But however, if the real judge is sitting there who knows about the law, he will say the reason for admission was not psychiatry, it was for some other reason. And incidentally, this happened before the psychiatrist is called or the psychiatrist treating them, and this happened, then invariably they will not take the cognizance of the offense. Invariably, the case will fall and they will not take any issue. But however, if we are going to treat such cases, it would be worthwhile registering the hospital for maybe 10 beds or something where we can admit and treat such patients. Hope I answered you, Sabina.
Yeah. Thank you. Thanks.
Yeah.
Any other question from the audience?
Yeah, many questions. Regarding confidentiality in child abuse cases, there is a question. CSA has occurred. Family is not willing to report it. I think we have answered it. Which gets priority? Violation of mandatory reporting or breach of confidentiality? So I think we have to report it mandatorily.
Yeah, see, anything, if you take even right to confidentiality, you name the fundamental rights, forget about the Mental Health Care Act, name the fundamental right. Right to life is not absolute. You can kill a person under the law. Procedural law is there. Procedural law means if you kill somebody, you have violated somebody's rights, right to life. So you will be put to the court will take a decision, and the court will give a judicial killing. For example, I can give you the best example is the Ajmal Kasab who came and killed so many people in Bombay. You can't kill him immediately. So it has to go through a judicial procedure. The process occurred and the Supreme Court said, yes, you can hang him. So that right to life is there, but still by the procedural law, you can hang him also. So similarly, even right to what we call it as right to freedom of speech is there to everyone, but you can't hurt somebody else. If you hurt somebody else by giving some stupid words or something, you can be booked under that. Similarly, all rights has limitations. That limitations you should know and work in that ambit. Similarly, right to confidentiality is not absolute. It is not absolute. Whenever there is cognizable offense, you have to report. You can't say that no right to confidentiality hai, hum nahi bolenge. That is not will be honored by the court of law. Any cognizable offense, it is the duty of the state and the duty of the citizens to report it because somebody else's rights have been violated. And it is the duty of every citizen to protect another person's rights. That is the way it will be interpreted. So all rights are not absolute, not 100%. So there is a leeway where you have to report, you have to break the confidentiality.
Alim.
Yes,
yeah, suppose patient calls me and says ki I am suicidal now. I am going to do something. So what to do? Suppose the patient is of my own follow-up.
Alim bhai,
yeah.
Do something means what? Suicide attempt.
Yeah, I want to kill myself.
I'm going to kill myself.
Okay. See, there are two issues here because there are a mixed group. Either it may be a psychiatrist, it may be a psychologist or a psychiatric social worker. If it is a psychiatrist or a medical practitioner, they come under telemedicine guidelines. So under telemedicine guidelines for any emergency care, what you have to do? 3 things we have to do. What are those 3 things? Counseling, first aid, referral for in-person. So you have to engage the patient and say what is happening, counsel him, and then you refer him to the nearest. If that person requires first aid, you may have to give first aid, tell him. Suppose if the person has taken some poison or anything. If somebody else is there, ask them to do the first aid, whatever is possible, which is done, and ask them to take him to the nearest RMP or the hospital. That is regarding the doctors. For the clinical psychologist and psychiatric social worker, they don't come under the telemedicine practice guidelines. But however, there is neither the RCI has formed any guideline. But what is the best guidelines available? The NIMHANS clinical psychology department has come up with the psychotherapy guidelines, where they also clearly said that whenever there is an emergency, do the counseling, first aid, refer them to RMP. They also have very clearly said RMP or else in-person consultation has to be referred. That is what they have written. The same thing has to be followed for even clinical psychologist. Unfortunately, for even psychiatric social worker, they don't come under either under RCI or MCI. But however, psychiatric social work department has come up with psychiatric social work guidelines from the NIMHANS. There also they have clearly written, whenever there is an emergency, please do the same thing: counseling, first aid, and refer in person. Don't hang up the phone. That's the basic funda. But however, suppose if a person is suicidal and is making 100 calls to Dr. Amrut and Amrut has kept the phone silent, will he be held responsible? No, he will not be held responsible, because every doctor has the what we call it as duty hours and non-duty hours. And it can happen with Dr. Amrut, it can happen with Dr. Suresh, it can happen with Dr. Alim. So nobody will be held responsible. To attend a case or not attend a case over the telemedicine or a telephone will be considered is the prejudice, or what we call it as it is the professional judgment by the doctor to attend or not to attend. If by chance, if it is emergency, by chance, I'll say this is my telemedicine number, but after 8 o'clock, I'm going to switch off. That's it. That is my personal way of dealing it. And if the patient calls at 1 o'clock 100 times and my phone is switched off, no law will be held responsible to me. But if you are switched on and you are receiving the call, you have to do these 3 things and document it. Document it, and tomorrow you go and file that, telling that yesterday night I got a call from this so-and-so number, so-and-so person called, this was the advice given. Anything goes wrong, imagine you did the counseling, you referred him, but he did not do, but he commits suicide. Will you be held responsible? No, you have done the minimum guidelines, what is required, which is done. You have done it, and you will not be held responsible, which Dr. Alim would have done, Dr. Amrut would have done, Dr. Suresh would have done. But however, some doctor may say, no, I would like to call the police station, or I would like to call the family members. These are all extra, you can do it, but it is not mandatory that you have to do it. That's the guideline says. But if you are able to locate because you have an amazing, powerful person, you can call the commissioner, and the commissioner immediately says, trace this phone number, GPS. Yes, that is not mandatory. But if you are able to do, well and good. But it is not mandatory. That's what I would like to put across.
But next day report to where? Next day kahan? Police station mein jaakar hum bolenge?
Sorry, I could not understand.
You said that the next day you have to
record it in the file, the patient's file. If it's your own patient, record it in the file.
Suppose was कई बार होता है कि उसने छोटा सा वीडियो रिकॉर्ड करके भेज दिया कि अब मैं दुनिया छोड़ने जा रहा हूं और ये वीडियो आ गया और मेरे पे पड़ा हुआ है.
Okay, so this is again, it is the professional discretion whether to attend or not to attend. But if you want to attend, you can attend, call back. And if they're able to pick up the phone, talk to them, counsel them, and refer them to the nearest RMP or the registered medical practice.
And call back nahi ut raha hai,
then you will not be held responsible.
So the other way around, I have a patient of borderline personality. I've been dealing with the patient for a long time. I'm attending Alim's marriage. I'm in the marriage ceremony. I have told everybody that I am not free. And suddenly I get a call when I'm just dancing. And then I got a call that, sir, I'm not feeling well. My mother did not buy me the new dress I saw in the mall. So I'm going to end my life. So this is a procedure that has been going on for a long time now. So I told, listen, I'm in a marriage, and for this, why and you really want to do it? Do it.
Don't do. See, that's the point comes. Don't say do it. See, that's the catch, Amrut.
No, that's what I'm telling you. We won't tell it, but there is some amount of something in my voice that makes people record a lot of things. Even if I don't tell do it, somewhere I do. I tell something and something happens. So is it abetment to suicide?
Oh, excellent question, Amrut. Okay, now this is one of the biggest question all of our psychiatrists are facing, because this abatement has been in the media for a long time. Let's understand about abatement. See, the suicide there are 2 types of suicide. One is deliberately committing self. So there is no punishment because the person has committed suicide. You can't, it's a deliberate. Now the abatement. Abatement means pushing somebody to commit suicide. So abatement comes under section 305 and 306. 306 is for normal people. 305, section IPC 305 is for child, for persons with mental illness, person who is intoxicated, person who is delirious. If you push them to commit suicide, the punishment will be 10 years or more. Whereas if a normal person, you push them to commit suicide or instigate them to commit suicide, under 306, up to 10 years it will come. But unfortunately, the definition of abatement has not been done either in 305 or 306. So we have to go back to the abatement under section 107 of Indian Penal Code. Under that abatement, there are three important points they have mentioned. One is either instigation. Instigation, I'll come to that shortly. Another one is if you are helping the person to commit suicide. That is called as assist. It is called as engaging the person. And the other one is helping the person to commit suicide. There are three important definitions. But unfortunately, again, this does not translate practically into the cases. So there are a couple of cases I would like to give example. I think the time is there. So abatement, one of the case which came is Ramesh Kumar versus state of Chhattisgarh in 2001. This is an interesting case. What happens is Ramesh Kumar is married to a lady. I think is a Seema Devi, if I remember. See, I'm taking the name of the people here because they are reportable case as per the Supreme Court judgment. So that is the reason I'm taking their name. And there is a frequent fight between this lady and this person, Mr. Ramesh Kumar. And Ramesh Kumar invariably may be asking for the dowry. And one fine day, there is a fight between, severe fight between both the husband and the wife. And Ramesh says, go and die. That is the way he says, go and die somewhere. So the lady, Seema Devi, what she does is she pours kerosene on her body and she lights the fire, and then she's burnt, occurred, and Burns is there. She's admitted in the Burns ward. In the Burns ward also, she says, I attempted suicide because my husband Ramesh did like this. He was asking dowry. And then after a few days, she dies because of infection and this. Now, there were two cases were put. One is abatement. Another one is dowry death case. So this case goes up to Supreme Court. There, the Supreme Court was very clearly said that the Ramesh Kumar wanted dowry, not to push them for committing suicide. So section 306 was dropped. But however, dowry death case continued. There they clearly discussed in this case about the abatement very beautifully. They say the instigation or the will or the intention, mens rea, was not to push the lady for committing suicide. It was for dowry. So they punished him under dowry harassment and dowry death case. And another interesting, one more case I would like to ask. So in the first case of 2001, Ramesh Kumar versus state of Chhattisgarh, it is the mens rea came into picture very good. Next is another one in 2010. This is Sheena versus Vijay Kumar Mahajan, 2010 in Guru Gobind University in a law college. This case happened. In this case, what happens is, I think a young boy, after writing some assignment exam, he comes out. His name is Mahajan. He comes out of the class. Suddenly, there is a mobile is missing. There are two people were found near the place where the mobile is missing. One is Mahajan, another one is Harminder Singh. I remember Harminder Singh. So Mahajan and Harminder Singh were found there. So immediately they were accused of stealing the mobile phone. So immediately both were taken to the HOD. Again, it is a law university. The HOD is the law professor. So he says, give writing, both of you give in writing your explanation. So Harminder Singh gives in writing, even the Mahajan gives in writing what happened. And the Mahajan starts crying, say, sir, I have not done anything. I'm innocent. Don't accuse me. I'm of higher integrity, all those things he says. Then he says, nothing can be done. There is an accused. You have to defend your case. So both the letters have been referred to the security officer of the university. So there the security officer does some inquiry and says, we will postpone the case for some few days, 3 or 4 days. Unfortunately, then 2 days down the line, Mahajan writes 5 to 10 page of death suicidal note, and he jumps in front of the running train and kills himself, naming the HOD, naming the security officer, naming the Harminder Singh, telling that Harminder Singh is responsible for taking all this phone, everything. And I have destroyed by the name of my family, my father, mother, excuse me, sorry, all those things he writes. And he jumps in front of the train, he dies instantaneously. And the case goes to the various place, and there was arrest warrant against the security officer, various people. When it goes to the Supreme Court, again, the Supreme Court said clearly, the person, the young boy, unfortunately was very sensitive. And he should have used all possible mechanism to overcome this problem. So if a normal person, what he would have done, he would have said, I have not done. He would have given a police complaint. He would have gone to the Human Rights Commission, or various other mechanisms are there, redressal mechanism. Instead of going there, he commits suicide. So he's a very sensitive person. This does not amount to abatement. So the second point came in. First one was the motivation. That was the mens rea. Second one is the person, the victim who is abatement is there. He has to exhaust all redressal mechanism. If he does not exhaust the redressal mechanism, abatement will not be given. Abatement occurs when the corner a person to a corner and he does not have anything else to do apart from committing a suicide. Then only abatement will go. That is the second case. Third, last case, a very interesting case. This is Indrajit Kundu versus State of West Bengal. This occurred in 2019. This is a young girl who is a girl who wants to learn about art, dancing. She wants to learn English now. So the family decides, okay, we will hire an English teacher. The English teacher was very handsome like Amrut. So he's teaching English to her. Both the boy and the girl fall in love now. So the girl says, I want to marry. The boy says, yes, we will get married. The boy takes the girl to his parents. The parents are very angry. No, we will not allow this marriage. There is a fight between the boy's parents and the girl. And in a fit of anger, the boy's mother says, you are a call girl. Call girl, they say. The girl becomes very upset, starts crying, goes back home, writes again a suicidal note telling that my boyfriend's father and mother, they called me call girl and my boyfriend did not do anything and I have been hurt and they should be punished. They should be put in jail. All those things she writes and she commits suicide. And that again goes to Supreme Court. The Supreme Court categorically said again here, there is no instigation. There was no mens rea. And all possible mechanisms of redressal were still open. It cannot be considered as abatement. Second. Third, there is very essential. See, so to call it as an abatement, the procedure should be very clear. First and the foremost, police has to establish it is a suicide. And then the abatement has to be proved, telling that there is an intention of committing suicide. And there should be a physical correlation and also temporal correlation. That means today there was an instigation and immediately few hours down the line, he committed suicide. It is not that he instigated today and the person commits suicide after 24 hours. That will not be considered as a abatement because there is 24 hours, a lot of things can change. So the instigation and the abatement should be temporal correlation. Not only the correlation, it should be physical correlation and also it should be the time correlation should be there. And also very essentially is there should be no option left to the victim apart from committing suicide. That should be established. Then only the abatement will be taken. Hope I answered your question in a very lengthy way. So abatement, four important points, I think 4 or 5 important points.
Yeah.
Establishing it is a suicide. There should be intention or motivation should be clearly said. There should be a very clear proximity or what we call it as temporal correlation or correlation with the time should be there. There should be a positive act and no what we call it as option should be left to the victim. The victim has to exhaust all the options. Then only if he commits suicide, then yes, abatement will be taken positively.
I hope the Republic TV people are watching you.
I think you should cut this word, Dr. Amrut. I did not say that Republic TV.
But suppose there is a suicidal action has been done. So हमको क्या पुलिस के पास जाने की जरूरत है? Do we need to report attempts to police?
Okay, so this is again, Alim, a very interesting question. So this is again, see, this regarding suicidal attempt, abatement of suicide. I have made videos in YouTube. If you subscribe to the channel at the rate of Suresh Badadmat in the YouTube, you will get all these videos. Abatement of suicide, attempted suicide, all those videos are there. So if you talk about,
you can put the link of your YouTube channel in the chat box. So
at the rate of Suresh Badadmat. At the rate of Suresh Badadmat, that's it. Suresh Badadmat, if you type in Google, you will get all the suicide or any videos of YouTube on legal issues are there available. Coming to the attempted suicide, if you look at the See, our Indian Penal Code is very old. It is 1852. Lord Macaulay has written this. When he had written this, they brought the church understanding. During that time, what they used to do is whoever has attempted suicide or committed suicide, they not only they punished him or his family, even if he has attempted, they would confiscate the whole property. The same thing transferred into our Indian Penal Code. Fortunately or unfortunately, in 1960, the England removed the attempted suicide case. But we continued because we are loyal to Britishers. And till 2017, attempted suicide was a punishable offense under Indian Penal Code 309 IPC. 1 year imprisonment with or without fine. But in 2017, Section 115 of Mental Health Care Act clearly says whoever attempts suicide will not be charged under 309 IPC. It will be considered as stress. That means if whoever attempts suicide will be considered as stress and they will not press the charges. That is the way the law has been written under Mental Health Care Act. But unfortunately, around 3 or 4 months back, there was a PIL in the Supreme Court. This is again an interesting case. A young person jumped in front of the elephant in a zoo to kill himself. Unfortunately, elephant did not do anything. This person was taken out, beaten up. Now what did they do was elephant was tied. So this person who filed a PIL was unhappy why the elephant was tied. They have all the rights, so animals have a right. They went to Supreme Court. Supreme Court was asking. They also said that this person should have been punished. So the Supreme Court has now asked whether should we keep Section 309 IPC or not. This is sub judice now. About whether the 309 IPC, why it is only for stress, why can't in various countries they have completely removed, why can't we remove this? Deliberate attempted suicide should not be punishable. That's what the court is asking. But at this point of time, the law is very clear. Whoever has attempted suicide deliberately by his own wish, it is considered by stress. However, if the police says that this is not because of stress, still 309 IPC can be put. Suppose imagine Dr. Alim says to a girl that marry me. If you don't marry me, I will kill myself. The police comes to know he is attempting suicide and by threatening somebody, 309 IPC will be punished because it is not because of stress. It is because of pushing somebody to marry him. So then it will consider it as 309 will be applicable in such situation. So that is the reason 309 IPC continues to exist, though it is said it is under stress only by default. But the police is able to prove the contrary. It is not because of stress. Still 1 year imprisonment with or without fine holds good today. But tomorrow the Supreme Court may say completely squash 309. It may say it is not far. That may happen. Hope I answered your question, Dr. Alim.
Dr. Suresh, however interesting the match has to be, the referee has to blow the final whistle. But then we always have the injury time. So we have one more question which I would like to ask. It is about fitness to rejoin duty. We have to give a lot of time. People ask us. People come to us. They are under treatment for depression, and they are corporate hospital. Corporate setups where we have to give them certificate. Should we give them that they were suffering from acute psychosis, which might be detrimental in the long run, even if they go for promotions. Even people might terminate if somebody is paranoid and then he has been treated. So how should we go about? What are the domains under which we should, people come and ask, give me a fitness certificate. Should I ask it from the employee or should I give it directly? Can you just, and that's the last question we'll take.
Okay, Amrit, so this is a very interesting question. There are two important. See, this is a fitness to rejoin the duty. Okay, that means he's already in a job and he has developed a mental illness. Now he has to rejoin the duty because he was on leave. Now the question comes is if the patient is your old patient. Okay, imagine it is Alim's old patient or Amrit's old patient or a Dr. Naveen's old patient. He is asking for a certificate, you have to give it. Okay, that is very clear because the diagnosis is very clear. He has a right to take a certificate under Medical Council of India or NMC Act within 24 hours. I think 24 or 48 hours. I forgot. You have to give the certificate. You will take it and you will produce it. Okay. A. B. He's the newly has come, first time he's coming and he has passed during the pandemic. He had maybe depression and now he's suffering from depression or he's coming out of depression. He's asking for a certificate. It is a new case. It may happen. Many times in the railways from West Bengal, many of my friend colleagues are referring those cases. They are working there. They have seen the cases or they have not seen the case. They have directly referred. It is a new case. Better to admit them and observe them. Yeah. So what are the parameters if it is a new case? First time they are coming to you and they are asking for a fitness certificate. Invariably in our hospital, Niemann's Hospital, what we do is we request a request letter from the authority or the employer, A. B, take the consent from the patient telling that we are going to do the assessment. The assessment may be detrimental to you, my certificate, and he is going to accept it. And invariably, if it is a new case, I would like to admit and observe them. And I will do various parameters of tests, maybe investigations, maybe detailed serial evaluation, serial MSE, ward observation, and the final, if required, some of the psychological testing I'll do, including CT scan, MRI, depending upon the symptoms. And at the same time, when I'm assessing, I will also assess for his responsibility as a job. What is his job? Whether he is a driver of a locomotive engine, that is railway, or else he is a soldier who is going to carry a gun. That means it is high responsible job, or else he is just a maybe attender in a place. To know the profile of his job. So depending upon his medical condition, depending upon his mental status examination, depending upon his job profile, depending upon his family support, social support, and if this is the first time, or else he had multiple episodes and he had stopped medication many times, that also we will take into consideration. Then we will issue a certificate. Invariably, after the Mental Health Care Act, what we do is we give the certificate to the patient. Patient will sign and take the certificate. When we are issuing the certificate, we will give three interpretations. One is fit to join back to duty, A, or else he is fit to join duty with environmental modification. That means he is a driver or he is a soldier. He will go back to work without ammunitions or without guns and ammunition. He will not hold. He will be environmental modification. He will be given a desk job. If he is a driver, he will get a desk job. And reassessment after 6 months. Invariably, we will ask that. The last one is he is completely unfit to go back to job. So these are the three ways we are interpreting and giving the certificate. Hope, Amrit, I have answered the question. Any other questions?
One more question we faced. I and Dr. Tufan sir faced. We got the CRPF people sent us 7 females who had tentative cuts on their hands. It was a very question. They had tentative cuts. So were they fit to be taken for a job?
Oh, this is again, the question is, if you ask me whether they are fit to join a job. It's not a rejoining job. They have not got a job. Before joining a job, they are asking for this. So this is it is a requirement of the job. If the job requirement says if a person with mental illness cannot be taken, so the definition of persons with mental illness will be taken from the Mental Health Care Act.
My question is very simple.
Okay.
They had no mental illness.
They have no mental illness. No problem.
Had one cut.
Tentative cuts are there. Okay.
One cut. Somebody has 2 cuts. 17, 14, 12 years back, 6 years back, 7 years back.
Okay. So there, I would rather do the assessment. And I will not even say whether they are fit or not fit. I will say they did not had any diagnosis. One, if they have diagnosis, I'll say they have this diagnosis. If they have borderline personality disorder, I'll say they have borderline personality disorder. If they have, they don't have any personality disorder, I'll say on evaluation on this date to this date, if I have a doubt, I may admit them for 1 week or 2 weeks and observe them and do a detailed psychological assessment. Or if I do MSc assessment and I would administer ICD-10 personality assessment and then say, yes, he has personality problem, I'll say there is a personality disorder. I will not comment on them whether they are fit to that job. I don't know, because even in the CRPF, there are various jobs available. It may be a attender job. It may be a job with ammunition and gun, or a driver. I don't know what is the job profile they are
So
applying.
we say that we have examined him today, and today we did not find any major mental illness.
Yes, that would be my response, Dr. Aleem and Dr. Amrit. I would comment whether they have mental illness or not, whether they don't, whether they have personality disorder or not, and they will just close it at there.
Suresh, last question.
Amrit, one question. Amrit, one question.
हर समय तू घुस मत.
दोनों लड़ाओ मत यार, please.
तू पूछना. I get
Okay,
a lot
we
of.
can have one more session.
I get a lot of letters from corporate hospitals. क्या अली मेरे को पूछने थे कि when I make a diagnosis that somebody is suffering from depression or schizophrenia, he needs leave. They're asking for evidence-based medicine. They tell that we believe in evidence-based medicine. So is it only the psychological testing that is the evidence for any disease, or how will we give them evidence?
See, Dr. Aleem, if the psychological testings were evidence, they were part of the diagnostic criteria. Nowhere there is a diagnostic criteria apart from IQ testing.
So what do we do when we get queries that we believe in evidence-based practice? So please give us evidence based on which you are making a diagnosis. Only the MSc if we send, will it suffice or will it not?
Okay, I'll come into this very good question. See, it is like this. You are a clinician, clinical based approach, and you are going to make a diagnosis based on the clinical points, and you have to document. I have found this A, B, C, D, E, F, G. This is my criteria under ICD-10. As per ICD-10, I'm diagnosing schizophrenia because past 1 month he had hallucination or delusions or first rank symptoms, and I'm diagnosing. So it is a clinical diagnosis. Nowhere it is called as evidence-based diagnosis. Nowhere it is there. Even if you take ICD-10,
my clinical examination is the evidence. This is the evidence.
Yes.
My word is.
It's not considered as evidence. It is called as clinical opinion.
Okay.
And again, coming back to both Amrut's question and your question, wrong diagnosis is not medical negligence. This is a Supreme Court verdict. The diagnosis opinion changes from one person to another person. A fever patient comes to a doctor. One doctor may say it is COVID. Another person may say it is bacterial infection. Another doctor may say it is just a fever for unknown origin. Another doctor may say it is a malaria. Another may say typhoid. So the diagnosis varies across just for a fever. Okay. Similarly, here in psychiatry, the diagnosis varies. Wrong diagnosis is not equivalent to medical negligence. So please document your clinical examination, your clinical findings. Without making any clinical findings, you are writing something, then it will be very difficult because the case will come after 1 or 2 years, you will not be able to remember it all. And you will not be able to justify in the court of law. So if you have made certain observation, document that. On this day, this person came with this history. On that basis history, I have found these things on my MSc. On that basis, under ICD-10, I have made a diagnosis or DSM-5. No person will say you, or even if it is a wrong diagnosis, nobody will punish you. And the court will never say it is a medical negligence. Let's be very clear about that. Wrong diagnosis cannot be considered as a medical negligence.
Okay. Boss, one last question from the chat box after 3 last questions from Amrit. So the question goes, suppose there is non-consummation of marriage. So is it a ground for divorce or impotency? How to prove it in court?
Okay, see, first and the foremost is non-consummation for how many days, how many months? Because invariably in India, there are certain culture where the boy and girl may not be allowed to stay together for a period of 1 month. In some places, it may go up to 2 months, or sometime it is a month called as, or a term called as Ashada, where husband and wife are not allowed to stay together. So if it crosses for more than 1 year or sometime the non-consummation continues, yes, non-consummation of marriage can be a ground for divorce. A. How to prove it? There are various Supreme Court judgment. The wife has to accuse him that there is non-consummation. She has to able to get examination done, and she says that yes, this is the reason. And then invariably the court may put him for testing or may not test. Just based on the non-consummation, basically the divorce can be given.
We have an interesting case here where the husband has accused the wife. It's a very high profile case that is going on now.
What is the...
The husband has accused the wife that non-consummation of the marriage.
Non-consummation, suppose vaginismus is there, so.
For how many years, how many months, how many years?
4 years.
If it is 1 month, 2 months, no court will say get lost.
4 years, sir, 4 years.
4 years, it's a ground for divorce.
So, chalo, we come to, Suresh, I think we should hand it over to the chairpersons, Dr. Sanjay, Dr. Naveen, for their comments, for their, then we'll.
Yeah.
Last question for them. Okay.
Yes, sir. Can I speak, sir?
Sure, Naveen bhai.
Yeah. Thanks, both the moderators as well as the speaker. It was a wonderful, very, very exhaustive session. I don't know. I think it started with registration and went on, and so it was a very nice, wonderful, practical discussion. Nothing more to add from my side. Thank you, one and all. Sir, Dr. Sanjay Kumawat.
Sir, please unmute yourself.
I've been hearing you last 2 years in on multiple platforms. And every time I hear you, there is some new addition for me as a take-home message. Today it was messages rather than message. And really, we feel great about you that, in fact, you know the cases also so well. I think you can be a better lawyer on mental health and medical legal issues. And of course, you cover the entire spectrum right, of the human life also, and the dimensions of mental health care also, various elements also of mental health. And this discussion can go on and on. There is no end to it, because the number of questions and the fight between Alim and Amruta, so much of competition to ask these questions. It was really a wonderful session. And now the only thing one must say that from inception of a case in any kind of healthcare,
Amrut, I'm unable to
mental health care delivery.
get any audio.
Sorry.
There is some problem with your audio, because we are all able to hear it.
Yeah,
Sir,
yeah.
sir, continue, sir. I will
Right.
tell you
So,
later.
right from inception of the case in healthcare delivery system, whether it is general or mental health care delivery system, right up to discharge and then fitness, rehabilitation, etc. There are various laws in place, and we must be aware of those laws. And that is when only we can legally practice safe with both clinically and legally. And that is most important for us, that we are aware of all these law. Over to you now, Dr.
Thank you, Dr. Sanjay sir. Sanjay sir is another big legal luminary. Whenever we need some advice, Dr. Sanjay sir is a father figure. We'll always tell dost, but a wonderful man. I treat him like he's a father figure to me. Over to Dr. Tufan sir. Sir.
Thank you, Amrit, and thank you, Suresh, for your fantastic, excellent lecture, which always is so. Many times I have heard you on web, and this was an exhaustive account of the practical facets related to psychiatry practice by GPs or in office. But one thing continues to haunt me. In many cases, it has been mentioned, you have told, that the interpretation ultimately lies with the judge. For example, a case is admitted in general hospital and he is having psychiatric problem. It can be before admission, it can be after admission. Before admission, one of my patients who is chronic depressive or affective disorder goes to hospital for a orthopedic injury and needs hospitalization for 15 days, 1 month. And in between he develops the symptoms. And it is not a 7-day emergency, and I have to intervene. And when I intervene, if I am charged, I am at the mercy of the judge. Judge may support my views, may not. So we continue to be in that dilemma. Is it so, Suresh?
Yes, sir. I completely agree with you.
So can we not make law a little more directed and objective? We must try to do that so that we know where we stand. We can discharge accordingly.
Sir, the law is very clear. Everybody should register. But unfortunately, we expect other to follow law, but we don't want to follow the law. That's the problem comes. We want everybody to register, but I don't want to.
We want to follow the law. I have a patient. He's under my treatment for many years. He's hospitalized for a physical reason. And the psychiatric symptoms flare up. And it cannot be solved within 7 days. The time margin given by the MSCA, nor he can be discharged from the hospital. And the patient, in his right, is not prepared to accept any other consultation. And the hospital invites me because they don't have any. And they are not registered. So I go, morally I am bound. Chalo jo hoga dekha jayega, I attend upon him. And sometime later I am charged. If I am charged, I am at the mercy of the judge.
I completely agree with you, sir. But the issue here is okay. But however, this issue can be settled in few years down the line. The reason being is we will have a national digital health mission where the government of India is going to have a similar to Aadhaar card. Everybody's health digital data will come in one place. Similarly, all the health hospitals will also come under that, where everybody will be registering under single name. No need to have multiple registration. That will be again one of the idea of this national digital health mission. There we will not we may not have many registration, and there may be only one registration where everybody will undergo telling that under the hospital or the health establishment registration may come in. that there is a discussion going on, having a multiple registration, have only one registration. That may be the answer, sir. But however, yes, these are all problems under the law. I do agree. Law is not answer for our social problems or issues of treatment. Invariably, there will be lacunae, and invariably, sometimes we may be left at the mercy of a one judge. But however, the appeal is there for High Court, Supreme Court. You can do that. So that's the way it goes, sir. But anyhow, for non-registration, they have kept 25,000 as the first punishment or the penalty, not the penal punishment actually at this point of time. Hope it can be reduced or amendments can occur over a period of time. Of course, yes, the mercy of the Mental Health Review Board plays important roles.
Okay, thank you.
Tufan sir and Suresh boss, how the law thinks and how we think. जो मेरी समझ में आया है कि how law thinks is in black and white, and the society and all the systems work in white, black and gray. So I think this gray period, gray area बहुत नहीं है वहाँ पर. वो कहते हैं कि बस 3 दिन के बाद है, खत्म है, उसके बाद करना है. अब हमको ग्राउंड पे जो बैठ के देखना है कि 3 से 4 दिन भी हो सकता है. So ये क्या हमारी बेसिक थॉट प्रोसेस फर्क है मेडिकल स्ट्रीम एंड सोसाइटी?
Let me tell you, Dr. Amrut and Dr. Alim, see, the judge has to do his job within the framework of the law. जो law में लिखा है उसको interpret करना है. He can't go beyond that. If he goes beyond that, he will be taken to task by the higher authority, higher courts. So he can't think beyond that. He has to work within the law of Mental Health Care Act. He cannot interpret beyond that. But as a doctor, I have been given a complete freedom. One is diagnosis, maybe some clinical diagnosis, especially in psychiatry. There is a lot of what we call it as the clinical judgment acumen. Many a time we don't rely on the, because majority of our medical fraternity is falling on investigation only. We don't fall on the investigation. We talk about the patient symptoms, patient as a holistic person, we treat. So the difference between the doctor and the judge is, judge has to work within the framework. जैसे कि chess खेलते हो, तो chess में इसी तरह खेलना है. That is being told to the judge. Judge has to play within that. The doctor has freedom. And we become our problem is we become emotional. ये मेरा patient है. जैसे कि I'll give an example. Like, अरे मेरा patient है, there is nobody to him. His father has left him. I will keep him in closed ward for next 10 months or 1 month or 1 year. That is the best for him. Arey bhai, it is good for you. You have thought as a paternalistic attitude. But the patient wants freedom, even 1 day freedom. You allow a patient who is inside the ward for 1 month or 2 months, allow him to go outside and see the smile on his face. He says, let me die, sir. Let me go out. That is the freedom. Even if you put somebody in a golden cage, nobody wants to be in the golden cage. Even it is a platinum studded diamond. The freedom and liberty plays a very important role. A best example is lockdown. Lockdown में हम लोग कितनी लफड़ाबाजी कर रहे थे घर में बैठने के लिए. We had a problem. We could not. We want to go outside. Imagine for a person with mental illness, you put him in a mental hospital or in the room or in a dirty place, whatever it is. You have taken the liberty. You have taken his complete liberty. So the judge has been given certain rules. You follow this legislation and interpret. He has to play within that only. He can't have any emotions. If he uses his emotions, the higher court, if it is appealed, he may not get promotion because he has made a wrong judgment. So this is how the judiciary thinks. So judiciary has to play within the framework. We have a larger framework.
Thank you. Thank you. Otherwise, Alim will keep on asking questions. So,
had a nice time with you all.
And there can be a lot of questions, but it is already 10, so I don't extend.
Sir, I'll close the session. Thank you from the IPS OSB. First of all, let me be very formal in thanking my very, very close friend. A phone call away whenever I have any issues. Totally unemotional. He'll give the advice which you might not like, but in the long run, that always helps. That is what Suresh is. He'll always tell you things which you don't like to hear, but then that is why you have called him up. That is Suresh for you. So thank you, Suresh. We had 222 thank yous, 722 wows, 270 registrations, and we had 190 at the peak, and it was very, you were only speaking, so, and we had 190 people listening to you. That is wonderful. Thank you so much. That Dr. Naveen Kumar, I always hold him in very high esteem. He's always the silent guy, never tries to, even if he's the captain of the team, he'll always be in the background, silent, shy, And when I heard about your publications, Alim would have had a heart attack. He has only 2.32 publications, and you had 232 publications. So that speaks a lot about you. Thank you, Dr. Sanjay sir. Sanjay sir is a father figure, as I told you. Thank you, Dr. Tufan sir. Again, another father figure. Alim, as usual, I don't want to thank him. He's one spoilt man. He's always in the gray zone. Thank you, our background team of
That's
Sharda,
a nice one.
Tazia, and Lucha. Thank you, IPS OSB, our president and secretary, for allowing us to do these things without coming in. Thank you, Torrent. Thank you, Pavan. Thank you, Dr. Amrit Patjoshi. You have been a wonderful host. Good night. Thank you so much. Thank you.
Good night. Good night. Bye.
And Suresh is here for the second time in Trust Musings, and hopefully he will be
Suresh,
here on more
Suresh,
occasions.
last comment. A lot of people who want you back again. Is it your jacket? Is it your background? I don't know, but they want you again.
Fine, no problem. Okay, whenever you call us.
Dr. Darpan was there. She wanted to ask a question and we missed it. Dr. Darpan?
I think it's time up, man.
Chalo.
Yes, that is why you closed.
Good night.
Bye, guys.
Thank you, everyone. Thank you.
Thank you, Suresh.
Of course, everything that is pleasurable is illegal, immoral, or fattening.
What?
वो आज कुछ डायलॉग सुना होगा नया इंग्लिश नया अंग्रेजी
हाँ, सीखा सीखा.
चलो गुड नाइट एवरीबॉडी सुरेश आई होप
Good night.
Night.
Right, Tufan sir.
Hello, good night.
Good night.
Good night, sir. I'll close the meeting.
Please do. Otherwise, Alim will keep on speaking.
You close the meeting, otherwise we will be here till you close.
Okay, sir. Good night.